So good afternoon, everyone, and welcome to this webinar. My name is Nina Murray, and I am Head of Policy and Research at the European Network on Statelessness. It's a real pleasure to welcome you all on behalf of ENS to our webinar today. Is Europe falling behind on statelessness determination and protection? So for those of you not familiar with ENS, we are a civil society alliance of over 170 individuals and organisations working to address statelessness in 41 countries around Europe. And we do this through law and policy development, awareness raising and capacity building. We are very excited to have had nearly 200 registrations for the webinar today. So do please say hello in the chat box and tell us your name, your organisation and where you're joining us from today or your country of work. It'd be great to hear from you. And in a moment, I'll tell you a bit more about what we've got in store for the webinar today and the lineup of fantastic speakers that we have. But first, just a very quick bit of housekeeping. So we are recording the session today and we'll make it available to everyone afterwards, so you can share the link with colleagues who aren't available to join us today. As I said, do please join us in the chat box, say hi, ask questions. The chat will not be visible in the recording, so that won't be shared afterwards. You'll note that participant microphones and cameras are switched off. So the only way to interact with us is through the chat box, so do please use it. Type questions as you go along and we'll leave time at the end to put some questions to our panelists. And also, of course, feel free to write to us, to email us afterwards with any further questions that we don't have time to answer today. We'd be happy to provide answers to you afterwards. So it's great to see a few hellos coming through already. I see people joining us all the way from the Philippines, from Kiev, from Estonia. So it's great to have you with us. Welcome. And we've already got nearly 70 people here, bang on time. So thanks for joining us. So today we are launching a new briefing on statelessness determination and protection in Europe, good practice, challenges and risks. And the aim of the webinar today is to provide an overview of the briefing and our recommendations for action to improve protection for stateless migrants and refugees in Europe. So the briefing is the third in a series of thematic briefings drawing on our statelessness index data. And the index, for those of you not familiar with it, is an online comparative tool that assesses how 27 countries currently, soon to be 30, in Europe protect stateless people and what they're doing to prevent and reduce statelessness. Last year, we published our first thematic briefing on birth registration. In July, we published one on deprivation of nationality and the prevention of statelessness. And today, we are excited to be launching the next in our series on statelessness determination and protection. And it's timely in that the launch of this briefing comes just over a week before a major international conference and technical meeting of experts on statelessness and the right to nationality in Europe, co-organised by the Council of Europe and UNHCR in Strasbourg. And we're delighted to have the Council of Europe's Director of Human Rights with us today as one of our panelists. So hopefully he can tell us a bit more about that important conference later. And we really hope that these resources will be a useful point of reference during the discussions in Strasbourg next week, and that they will lead not just to commitments, but to action to address the protection gaps facing stateless refugees and migrants in Europe currently. So colleagues, I believe we'll be sharing the link to the briefing now. It's available on our website as of today, and we should get a link to you in the chat very soon. So I think we're going to start with a quick poll to see how you are all on your knowledge about statelessness determination procedures. So my colleagues should be posting that poll shortly. Here we go. So a quick test for you all. What's the number of countries with SDPs in Europe currently? So tell us what you think. While you're doing that, I see we have others joining us all the way from Kenya, from Germany, from Georgia, Spain, Netherlands, the UK, Turkey, Moldova. Fantastic to have you all with us. Thank you. And while we're waiting for the poll results, I'll maybe tell you a little bit more about what we've got in store for you during the webinar today. So the agenda for today, first we're going to hear from my colleague Patricia Cabral, who's our legal policy officer. She's going to summarize the briefing for you, setting out some of the good practices and gaps that we've highlighted, as well as our key recommendations. After that, we're delighted to have a fantastic panel of experts to talk to you today. And first of all, we have Lynn Khatib, who's going to share her reflections on what happens when a country doesn't have a procedure in place to identify and determine statelessness. We're then going to hear from Marlotte and Dael, who's going to tell us a bit more about work in the Netherlands to introduce a new SDP and some of the challenges around this process. And then, as I mentioned before, we'll hear from Christophe Poirel, Director of Human Rights at the Council of Europe, who's going to tell us a bit more about plans for the conference next week and give us the perspective of the Council of Europe on these key issues of identification and protection of stateless people in Europe. And then, as I promised, hopefully we'll have time for some questions. So please do get your questions ready and post them in the chat, and then I'll put them to our speakers at the end. So before I move to our first speaker, have we got a result from the poll? We do, pretty good. Okay, so most people are more or less correct. So the largest number of people have suggested there are 6 to 10 countries in Europe that have a statelessness determination procedure, closely followed by people who think 1 to 5. And then others are kind of mix of the other options. So it's a little bit of a trick question because it's a bit debatable how many countries, but in our assessment, we think there are 11 countries in Europe that currently have a statelessness determination procedure. And if there's time, we can explore which countries in more detail later on, but pretty good. I'm impressed. So you must have some knowledge of statelessness determination and protection. Great, thank you for that. So without further ado, I'm going to introduce our first speaker. So Patricia, who I said before is our legal policy officer at European Network on Statelessness. I'm going to hand over to you, Patricia, to tell us more about the briefing. Over to you.
Hi, Nina. Thank you so much. And I will try to briefly introduce some of our conclusions from the briefing. I do encourage you all to read the briefing, of course, and I will be drawing on some of the examples that we have of good practice and barriers in our briefing. And please note that some of the examples that we will be mentioning here are only examples, and we're mentioning other examples in the briefing as well, and so please don't take into account everything that is here. But I will try to provide the summary of the key essence and issues. So why do we need statelessness determination procedures? First of all, a stateless person is someone who is not considered as a national by any state under the operation of its law. And this is the 1954 Convention definition. In Europe, statelessness affects both recent migrants or refugees and those who have lived in the same place for generations. And these are considered stateless in situ. So they have long established ties to the country where they are living. And it is important to distinguish between the solutions that are required to address in situ statelessness and statelessness in a migratory context. For people who are stateless in situ, the solution is not to grant them a protection status that prolongs their statelessness. It is instead states should confirm or grant nationality to those who lack it, and including through targeted nationality campaigns and eliminating discriminatory laws and practices. In the case of stateless migrants or refugees, then states should first identify and formally determine their statelessness and then grant them protection according to the 1954 Convention. And this is best fulfilled through a dedicated statelessness determination procedure, or an SDP. So if a stateless person applies for asylum, it is important to determine both their claim for international protection and their claim for statelessness. And in the report, we explain a bit more how these two are linked and the relationship between them. the key 5 elements that must be in place for an effective SDP to be established and to lead to adequate protection and reduction of statelessness are these 5 that we can see here in this graphic. So first of all, states must accede to and comply with relevant international instruments, including the 1954 Convention on the Protection of Stateless Persons. 2, there must be information available on the issue of statelessness, and authorities must be competent to address the issue. There must be a procedure to determine statelessness, and then that determination must lead to an adequate protection status. And finally, we have the item of access to nationality. So stateless people should have facilitated routes to naturalization to be able to ultimately resolve their statelessness. And we will now see how the index countries perform in all of these areas. So our report shows that most of the countries in Europe are yet to introduce a dedicated SDP. And you were right in guessing that in the poll. And so 25 of the 27 countries that we assess in the index are party to the 1954 Convention. But there is still a big gap between acceding to the convention and implementing these obligations in practice. Out of the index countries, only 10 of them have dedicated procedures to identify and determine statelessness, which leads to a protection status. And these are listed here under a positive and somewhat positive score, depending on differences in shortcomings in their procedures. Switzerland also has an SDP, but it is an administrative procedure and it is not formalized in law. Then Belgium, for example, also has a procedure to determine statelessness, but it does not lead to a protection status. Therefore, we do not consider it to be an SDP, and it is assessed here as somewhat negative. In Albania and Serbia, there is a statelessness status, but no procedure to determine statelessness. And then in all the other countries in the index, there may be some mechanisms through which stateless people might be able to have their statelessness identified or to regularize their stay, but the purpose of these mechanisms is not to determine statelessness, and so this still results in significant protection gaps. We'll now assess different aspects of the process of determining statelessness according to the countries that have an SDP in place in the index. In terms of the definition of a stateless person, some countries have incorporated the definition that is in line with the 1954 Convention. In others, the convention has direct effect, but there are still countries that have not fully incorporated the 1954 Convention into their domestic legislation. And in other countries, there are narrower definitions of a stateless person that do not take into account how the laws are applied in practice by the authorities of the relevant state. And another common issue that we found is that several states have introduced additional grounds to exclude stateless people from the protection that go beyond the 1954 Convention. And one example that we show here is Bulgaria, which introduced a recent amendment to the law that means that stateless people will be refused protection status if their identity documents are expired, if they are issued a removal order for irregular stay, for example, or if they lack the required means of subsistence. It is also essential to have safeguards in place to ensure that the SDP is accessible to everyone and that there are no bureaucratic hurdles that may impede access to protection. So this is essential for an SDP to be fair, efficient, and non-discriminatory. Now, research shows that most countries in the index do not impose time limits, fees, or lawful residence requirements, which is a positive thing. However, application procedures are often complex. There's very limited information available to applicants, or it's only available in one language. There are significant language barriers that are not addressed. And another important thing to consider as well is that many times the applicants are not able to initiate the SDP themselves, or they may be afraid of approaching the authorities. And therefore, it would be important for authorities to be able to initiate the procedure ex officio, but this does not happen in most of the countries. In terms of the assessment of applications, states must put in place fair evidentiary requirements. And so there are a number of items to consider here. One of them is that the burden of proof should be shared. so that both the applicant and the authority cooperate to obtain evidence and establish the facts. And it is also recommended that the standard of proof is the same as in refugee status determination procedures. So the applicant should be determined to be stateless if it is established to a reasonable degree that they are not considered as a national by any state under the operation of its law. And in many countries, the assessment of statelessness falls short of these international standards, and the clear evidentiary rules are lacking, or they do not take into account the difficulty of proving statelessness, or the burden of proof may be on the applicant. And for example, in Switzerland, the standard of proof is even full proof, which is a very high standard and very difficult to evidence. States should also implement measures to prevent discrimination against disadvantaged groups, but these are very rare among index countries. And in general, there is a lack of child rights-based SDPs as well. And you can see here a good example from Ukraine, where the law recognizes the additional support needs of unaccompanied minors, people with disabilities, and people with language literacy or health-related barriers. And there's also the possibility for the authorities to carry out a home visit or a visit to a medical institution to interview the applicant. And these are all things that were established now by the recently introduced SDPs and bylaws in Ukraine. There are also a set of minimum procedural safeguards that an SDP must include, and we have more details about this in the thematic briefing. But for example, applicants should be offered free legal aid, interpreting and translation services. They should have the right to an individual interview, and decisions should be in writing and within a reasonable time limit of no longer than 6 months. Common barriers that we found in terms of procedural safeguards include the lack of legal aid, significant language barriers again, and no access to an interview, no opportunity for stateless people to claim their rights. And then there are delays and errors in decision making as well in several countries. Then if the SDP leads to the conclusion that the person is not stateless or is not entitled to protection, there should be an effective right of appeal to an independent body against that negative decision. In appeal proceedings, applicants should have access to legal aid and to representation, and the appeal procedures should be free of charge or covered by legal aid. And although there are some barriers in practice, there is actually a right of appeal to an independent body in all countries that have an SDP, except for the United Kingdom. It is also important to note that during the SDP, applicants still receive the protection of some provisions of the 1954 Convention. So even while the applicants are waiting for a decision, they still have the right to receive identity documents, the right to work, to healthcare, education, and social security, and to be protected from expulsion and detention. And unfortunately, Moldova is the only index country to be assessed positively in this area. Some countries provide basic rights during the procedure, but the protection afforded is rarely in line with international norms and good practice. So for example, residence rights vary greatly between different countries. In some countries, applicants are not granted the right to reside, or this may be discretionary, and therefore they are often at risk of expulsion and detention. Then, assuming that a person has gone through what was hopefully a fair, efficient, and accessible procedure and was recognized as stateless, this recognition must lead to the granting of a statelessness status. So according to international guidance, this should include a renewable right to reside for a minimum of 2 years, and preferably up to 5 years. People should receive travel and identity documents. They should have the right to family reunification, permission to work, to access education, social security and healthcare, and also the right to vote. In almost all countries that have an SDP in place, the procedure does lead to a protection status. And where it doesn't, such as in Belgium, we don't consider it to be an SDP, but I will also talk about this in a moment. There are still several issues with the protection status afforded to stateless people across Europe. And in several countries, the residence permit is not granted automatically, or it is only valid for short periods of time. And in some countries, the access to social and economic rights is linked to the residence rights as well, or is restricted to people that acquire permanent residence. So there are still quite a lot of shortcomings as well in this area. You can see a good example of good practice in this area from Spain, where the recognition of statelessness results in an automatic permission to stay and indefinite right to reside, and stateless people are granted all the economic and social rights, and according to the 1954 Convention, on the same basis as their nationals. Now, I will take a few seconds just to stress the importance of the routes to naturalization. So the only way to resolve statelessness is to acquire nationality. The granting of a statelessness status is only a temporary measure to protect people until their statelessness is resolved. So to reduce statelessness in a migratory context, states should also expedite naturalization procedures for stateless people, including by exempting stateless people from requirements such as citizenship or integration tests, language tests, application fees, or minimum income requirements. And states should also not unreasonably prevent stateless people from acquiring nationality by imposing strict requirements related with good character or criminal convictions. And as you can see in this slide, there are no countries with an SDP that are assessed positively in this area. Several countries have high application fees. The residence requirements vary greatly, and sometimes they require people to live up to 10 years in the country since they've been recognized as stateless. And many countries also impose discretionary good character requirements. Stateless people are also very rarely exempt from language, citizenship, or integration tests. So as I mentioned at the start of the presentation, 17 of the 27 countries in the index do not have an SDP leading to protection status, even though 15 of those 17 countries have acceded to the 1954 Convention. So it is about implementing these obligations and putting SDPs in place for stateless people to actually be able to access the protection from that they are afforded to by the 1954 Convention. Among the countries that don't have an SDP, there are some trends as to how they address statelessness, even though none of these actually protect stateless people. So first, there's the case of Belgium that has a judicial procedure to determine statelessness. So the family courts can actually identify and determine that a person is stateless, but that does not lead to automatic residence rights or to any rights of the 1954 Convention. Then in some countries, people recognized as stateless who cannot be returned to another country may be issued with a tolerated stay or a tolerated status. And these are, for example, Germany, Poland, and Slovenia. But these tolerated stay statuses are normally of short duration. They last only 6 months to 2 years on a renewable basis. And some rights may be granted, for example, the right to work and to basic social assistance, but these rights are generally restricted and they are not in line with the protection that should be afforded to stateless people, according to the conventions. Then in most countries, there are either ad hoc or established routes through which some stateless people may be able to regularize their stay in the country and access some rights. And these may be procedures in the context of applications for asylum or for residence permits or applications to acquire nationality. However, statelessness determination is not the specific objective of any of these mechanisms, and the routes to regularization rarely lead to rights that are actually linked to statelessness per se. In some countries, there are not even any mechanisms to identify statelessness, for example, in Portugal, and especially not outside international protection procedures. And finally, there are also countries that have a statelessness status established in law, granting some rights to stateless people, but they do not have any procedure to determine statelessness. And this is the case of Albania and Serbia. We should note that in all of these countries, states are failing to uphold the rights of stateless people. They are leaving many facing years of uncertainty and social exclusion. They're at risk of detention, of expulsion, and of other human rights violations. And therefore, of course, we welcome any pledges that states have recently made to introduce SDPs. And we are also quite glad to hear that some countries like Malta and Portugal have been progressing to introduce SDPs. And this will be extremely important to actually protect stateless people and eventually resolve their statelessness. And finally, I want to close on a positive and encouraging note, and I will highlight the 4 key areas where we recommend that action is needed by governments, by legislators, and by decision makers to ensure that stateless migrants and refugees in Europe can access protection and resolve their statelessness. So first, it should introduce fair and accessible SDPs in line with international norms and good practice. And the countries that have not acceded to the 1954 convention yet should also accede to the convention and introduce the SDP. 2, we should ensure that SDPs lead to a dedication protection status for people recognized as stateless. And 3, we should provide specialized training on statelessness and nationality rights and ensure cooperation between relevant public authorities. And finally, states should ensure that stateless migrants and refugees have an accessible route to naturalization to ultimately resolve their statelessness. I do encourage you again to read the report, but I will leave my presentation here for now, and I will be happy to answer any questions at the end.
Fantastic. Thank you so much, Patricia. That was a really comprehensive and clear overview of the briefing. And just a reminder again, for those of you that haven't seen it yet, there's a link in the chat and you can access it on our website. So thank you very much, Patricia. We'll come back to you, I'm sure, at the end for some questions and further comments. But now I would like to turn to our panel of invited experts to hear some of their reflections and responses and recommendations for the way forward. So first of all, it's a real pleasure to introduce you to Lynn Khatib. If you're there, Lynn, you can turn on your camera. Hi, Lynn, welcome.
Hi.
So Lynn is a stateless activist and individual member of ENS based in Sweden. And Lynn is going to tell us a bit more from her perspective about what needs to change in this area and what the impact is on stateless migrants in Europe. So Lynn, over to you.
Thank you, Nina. So we're going to start talking about it from my perspective, being a stateless person living in Sweden. Sweden, a country that is considered as a good friend for the UNHCR's campaign I belong, and whenever they're in Geneva, you just hear their very positive and enthusiasm when it comes to statelessness. But when you come to the real world here in Sweden, this is not really the case. Not only here in Sweden, we don't have a SDP procedure, we really don't see statelessness as a problem here. And it's like they might consider statelessness in an ad hoc way here, that by the migration agency, for example, but we don't really have any official guidance about how to do. And sorry, am I still on?
We can hear you, Lynn, thanks.
Yeah, and when a country is lacking the statelessness procedure, it means that their official officers and their lawyers, they don't really have the awareness or the knowledge or any kind of practice how to deal with statelessness. And usually it is separating statelessness from the stateless person when it comes to migration and refugees, that it's not considered as the main issue here, which leads to people being rejected as refugees and being left in a hell that's called limbo here. And I'm one of those people that my application got rejected among a lot of other people. And since being stateless doesn't really allow us to go anywhere freely, so we were stuck in a position where we can't stay in Sweden and we can't leave. And I think all of this could have been much easier for people in my situation if Sweden actually had some kind of procedure to prevent or determine statelessness. There are still no number about how many stateless people living in Sweden. According to the Swedish Organization Against Statelessness, there's more than 30,000 stateless persons that are left in a limbo and are at the risk of being paperless. Being paperless in Sweden means that you have absolutely no right whatsoever, that you don't exist on paper and you don't have any access to the least of your rights, which is a real hell. There are families with kids that have been born here, but since we don't really have a nationality law that supports stateless people, these kids are born stateless, even though they lived their whole life in Sweden. They know nothing but Swedish and been integrated in the Swedish society. They're still considered stateless, and they're still considered with their families that are being deported but stuck here in Sweden. I it just yeah, I'm just, the thing is, I'm as a person, I'm tired of talking about me being stateless. I really hope that soon I'll be talking about me being an ex-stateless, and now it is solved and there are hope for other people to get rid of their statelessness. But if there are no procedures in countries like Sweden that actually works on this, so I don't really see that much of a hope of, if we're talking about a Belong campaign, that statelessness will end by 2024. I think we're really being behind. And just like, we don't want to band-aid the issue. It should be like, as Patricia said, the solution for this, it would be giving people nationalities. And I'm not a politician or an academic, and I know it might not be that easy, but at least to take some steps towards the right path. I would really love to see countries like Sweden or the Netherlands actually doing that, and have some hope that for people in my situation, millions of other people, that we can finally have our own choice, that no one else is making a choice for us, and we can choose our own fight. Yeah, so that's for me. Thank you, Nina.
Thank you so much, Lynn. Thank you, as always, for really eloquently sharing your own experience and the experience of many, many others like you. And it's really, really important that we have you with us today to share those reflections and recommendations for how to solve this intractable, what seems like an intractable problem. But I think it's really important to hear your voice and voices of others like yourself with that direct experience in order to really help shape and inform and lead the change that needs to happen. So thank you so much. We'll come back to you at the end for some further thoughts, but for now let's move on to our next speaker. So next we're moving to the Netherlands, and I am delighted to introduce you to Marlotte. If you'd like to turn on your camera, Marlotte, who works for ASKV Refugee Support, which is an NGO that provides legal and social assistance to undocumented refugees and migrants in Amsterdam, and has been a long-standing member of ENS. And besides her work as a legal caseworker, Marlotte is currently responsible for coordinating the organisation's activities around improving the situation of stateless people in the Netherlands, which includes work on litigation, advocacy and research. So we're really excited to hear from you and your experience, Marlotte, what the situation is in the Netherlands. So over to you.
Thank you very much, Nina, and good afternoon to everyone joining today. First, I would like to respond to Lynn's speaking, and it's very concerning to hear the situation and the issue you are facing in Sweden. And there are unfortunately also a lot of similarities with the Dutch context. At the same time, as Nina said, it's also very inspiring to hear what you are doing to effect change and the importance of it. I also briefly want to comment on the briefing on the statelessness determination and protection in Europe, published by ENS. as I think it provides a great foundation for what countries should focus on to make sure that stateless persons are provided with their rights, and therefore also a great tool for people working on the topic to urge their governments to address the shortcomings and move forward towards good practice that is already implemented in some other European countries. This is, for example, the case for the Netherlands, which scores on the negative end in the statelessness index compared to other European countries. The Netherlands is currently in the process of introducing an SDP. And before I talk further about this, I would like to provide a quick background on what the current context looks like without an SDP in place. For stateless persons arriving in the Netherlands that ask for asylum, the Dutch Immigration Office has the responsibility to assess their identity and nationality as best they can when deciding on admissibility of their claim. However, an independent assessment of statelessness is not in place, and stateless people can face great difficulty evidencing their statelessness in the asylum procedure, especially when there is a lack of identification documents. In addition to the fact that statelessness is not a ground for a protection status, the lack of a mechanism to determine their statelessness also potentially further complicates their chances of obtaining a residence permit on other grounds, as it may leave doubts in place about their identity and origin. If this results in a rejection, a prolonged period of stay in the margins of society often follows, while they are also not able to leave the country. For people with a residence permit, there is an administrative procedure to be registered as stateless in the Dutch population register when there are sufficient identity documents evidencing statelessness, or through a statement by the Dutch Immigration Office. Having said this, this procedure is only a registration procedure and does not assess evidence beyond standard identification documents or a straightforward rule of nationality law. Registration as stateless in this population register does provide additional legal rights, including facilitated naturalization. However, due to the high burden of proof and the absence of an SDP, almost 43,000 people were registered in the category of nationality unknown as of January 2019, among which an unknown number of stateless persons. And they can face great difficulty obtaining Dutch nationality due to documentation requirements in the naturalization procedure. In 2011, a mapping of UNHCR resulted in a critical report about the situation for stateless persons in the Netherlands, especially concerning their identification and registration. And as a result, the Dutch government requested the Dutch Advisory Committee on Migration Affairs to advise them on the matter, which they did in their 2013 report, confirming UNHCR's finding and critiquing the Dutch government for its shortcomings around identification and registration, as well as the lack of a protection status and difficulties accessing Dutch nationality. This, and in addition to continuous advocacy by civil society, led the government to commit to introducing new legislation to address the situation. And consequently, in 2016, the government published a draft law for public consultation. The process that followed has been long and challenging. It's now 5 years since the draft law has been presented and 10 years since the condemning reports by UNHCR, but there's still no SDP in place. Long delays by government, either due to other pressing subjects, new elections, and more general strong hesitancy by especially the Prime Minister's party, VVD, to introduce additional rights that they feel is closely linked to the migration debate and is therefore labeled as controversial. Ultimately, and after continued advocacy as well as litigation by civil society to urge the government to move forward with the introduction of an SDP and improve its initial draft law, 2 revised legislative proposals were finally submitted for consideration by Parliament in December last year, which coincided with the judgment of the Human Rights Committee in the Dael case, in which they found that the Dutch government's failure to identify and assess a child's statelessness led to a violation of their right to a nationality. The two revised draft laws cover two matters: the introduction of an SDP and a proposal to amend the Dutch Nationality Act to enable stateless children born in the country without a residence permit to opt for Dutch nationality. And while it's very welcoming that a dedicated mechanism in place to determine statelessness, there are significant shortcomings, of which I want to mention two. One is the fact that statelessness determination will not convey any residency rights, effectively leaving the stateless person to continue his or her life in limbo. And the second is the requirement of 10 years of stable residence for stateless children born in the Netherlands without a residence permit before they can opt for Dutch nationality, as opposed to 3 years for stateless children with a residence permit. The stable residence of the child is also conditioned on the cooperation of the child's parents with the Dutch immigration authorities. By choosing this interpretation of an SDP, as well as limiting the right to a nationality of stateless children without lawful residence, the Dutch government goes against the recent judgment by the Human Rights Committee, as well as numerous previous recommendations, while it also falls short of its international commitments. And the reason for this, which brings me back to my earlier point on the government's hesitancy to introduce additional rights that is linked to the migration debate, is, according to the government, due to a fear for a potential pull factor if an SDP is introduced that conveys residency rights. They also don't want to reward parents that stay in the Netherlands after their asylum procedure has been rejected by providing Dutch nationality rights to their children. Finally, there's also a belief by Dutch governments that in principle, most, if not all persons, as well as stateless persons, can return to their country of origin or former habitual residence after their asylum request is rejected. This is a difficult political climate to operate in, but we can continue to counter unfounded fears and myths through available evidence that proves the contrary and address their rights under international law. We are also still optimistic that proposals for amendments to the draft laws by other supportive members of Parliament could potentially lead to positive changes to the draft laws. And we are currently waiting for a date to be scheduled when the laws and possible amendments will be voted on by MPs. If the draft laws are adopted, but not further amended, leaving the problematic issues surrounding residency rights and nationality rights for stateless children without lawful stay in place, this would still mean progress for stateless persons, as it will finally provide them the opportunity to officially determine their statelessness. But it will also mean that civil society needs to continue its advocacy and further fight for the additional rights through the courts for stateless persons without lawful residence. Thank you.
Thank you, Marlotte. Thank you very much. And that was a really, really useful and important overview of the current situation in the Netherlands and the work that you're doing there. And thank you for that and for your work. And I think both your and Lynn's interventions really illustrate the importance of why statelessness determination procedures are so important and so needed. So it's clear, you know, it's very clear from your interventions that we really need more action and we need it urgently. You know, next week's conference provides an opportunity to move this debate along, hopefully. And I'm really excited now to be able to introduce you to Christophe Poirel. Christophe, if you're there, hopefully the connection problems have been resolved. Fantastic, welcome. So Christophe has been Director of the Human Rights Directorate at the Council of Europe since 2018. Prior to that, he served in several positions within the Council, including as Deputy Secretary to the Committee of Ministers. Christophe is a friend of ENS, and we're looking forward to hearing your comments and responses to the briefing. So I'll pass over to you, Christophe.
Well, thank you very much, Nina. I hope the connection is okay now. Very good, very good. So many thanks again, Nina, and to the colleagues in the network for the invitation. I'm very pleased to be with you today. As I said, when I participated in a previous event, I consider that personally as a very important issue, and I'm trying to follow developments as much as I can, both within and outside our organization. I would like also to congratulate you for the very useful briefing paper on statelessness, determination and protection in Europe. The presentation made by Patricia was indeed very illuminating, I would say very clear and comprehensive, as you said yourself, Nina. What I found interesting in the presentation, if I understand correctly, is that in some countries, at least, if not in all of them, you have at the same time positive elements in the domestic legislation, but you have also shortcomings. So which shows also that even in countries where those procedures exist, there is at least still room for improvement in a number of them. Talking about the Council of Europe, perhaps I should say a few words first about the Council of Europe, because I understand there are participants from outside the European continent and they may not know who we are. So the Council of Europe is an intergovernmental organization which is comprised of 47 European states. The only European country that is not a member of our organization is Belarus, because Belarus does not comply with our values and standards in terms of respect for human rights, democracy, and the rule of law. I must say the protection and identification of stateless persons are among the priority areas of our organization to address statelessness. On several occasions in the past, our Parliamentary Assembly, which is the body that brings together delegations from our national parliaments. So on several occasions, the Assembly has called our member states to introduce or upgrade existing statelessness determination procedures in order to ensure that all stateless persons in their territories can be identified, protected, and ultimately, as was mentioned before, acquire nationality through facilitating naturalization. Through our various bodies, we have been actively working on various aspects, in particular the issue of access to nationality and the prevention of statelessness. I would mention the most significant instrument we have, which is the 1997 European Convention on Nationality, which provides specifically that everyone has the right to nationality and that statelessness must be avoided. This instrument, which is a legally binding instrument for those states that have ratified the convention, was complemented over time by other binding or non-binding instruments. I would refer to the 2006 Convention on the Prevention of Statelessness in relation to state succession, or, for instance, the Committee of Ministers' recommendations on nationality of children and on the avoidance and reduction of statelessness. To date, according to our calculation, and then there is a slight difference between the figure you mentioned at the beginning and our figure. Today, according to our calculation, only 12, not 11, 12 Council of Europe member states have a dedicated SDP and a stateless protection status. I noted that in our list, we have Bulgaria, France, Georgia, Hungary, Italy, Latvia, Luxembourg, the Republic of Moldova, Spain, Turkey, Ukraine, and the United Kingdom. So perhaps this will help you to compare your figure with our figure. There is one country that is missing in our list, which you mentioned, which is Switzerland. So we need, I think, to compare our notes on that point. But anyway, to date, as I said, only 12 countries have a dedicated procedure. And also I would like to quote another figure, which unfortunately has not changed since last year, which is that according to the latest UNHCR estimates, there are still around 500,000 stateless people living in Europe, including those with undetermined nationality. And of course, such figures are of particular concern. The Council of Europe is very conscious of the need to strengthen the protection of human rights and to ensure the effective enjoyment of basic rights for the most vulnerable, including, of course, stateless people. In this respect, we are committed to support our member states in our efforts, either to establish or where necessary to improve the functioning of statelessness determination procedures so that these persons have access to their rights, including the right to acquire nationality, in particular for children. I must indicate that following an analysis that was carried out by one of our committee of experts, the European Committee on Legal Cooperation, a study and analysis on current practices and challenges regarding the avoidance and reduction of statelessness in Europe. So following that analysis, as you mentioned at the beginning, Nina, the Council of Europe and the UNHCR are jointly organizing an international conference on statelessness and the right to nationality in Europe on 24 September, so in 2 weeks' time. And I'm very pleased that the ENS has taken a particular interest in this event and will actively contribute to the conference, which will provide an opportunity for our member states, national experts, high-level representatives from international organizations, civil society representatives, representative of the academia, and also stateless individuals to exchange views on how to successfully contribute to ending statelessness in Europe and guarantee the fundamental rights set out in relevant international and regional treaties. As you all know, better than I would say, the issues and challenges of statelessness are complex and should be taken forward in close partnership with all relevant actors. So during the conference that we will organize in 2 weeks, a specific session will be dedicated to the question of how all actors can build strong partnership, both nationally and internationally, in order to eradicate, I would say, statelessness in Europe. Prior to the conference, there will be a technical meeting of experts, which will be held the day before, on 23 September, during which participants, in particular national practitioners, will be invited to discuss current trends, outstanding gaps, shared challenges and practical difficulties in respect to the identification of a stateless persons and how to guarantee their rights and protection needs. So I trust that some of the issues that are raised by the very comprehensive briefing paper that you have published today and the Statelessness Index as well, which monitors progress in Europe, will be at the core of the discussions of our event. Last but not least, I would also like to underline that the Council of Europe Action Plan 2021-2025 on protecting vulnerable people in the context of migration and asylum in Europe, which was recently adopted by our Committee of Ministers, focuses notably on ensuring access to justice, an essential component, of course, of the rule of law, where it is crucial to promote the legal empowerment of refugees and migrants in vulnerable situations, including stateless persons, through the provision of information, legal aid. That was one of the points you noted in the presentation. So provision of information, legal aid, legal representation, and also child-friendly justice initiatives. We also hope and trust to be able to work closely with all of you on these issues during the time frame of the implementation of the action plan. As I said before, and I don't need to say that in a way, it is only by joining forces that we will ensure that Europe and our 47 member states do not fail stateless individuals. And with that, thank you very much again, Nina, for the invitation. Many thanks also for the two persons who spoke before me. I think, at least for me, I'm a bureaucrat staying in his office, if I may say so. So as a bureaucrat, it's always interesting and useful to hear first-hand experience from someone who is the victim of the situation. And I feel sympathy for the colleague from Sweden to hear the difficulties that are encountered by people like her, but also, sorry, the presentation that was made by the other colleague about the situation in the Netherlands, which I found personally very interesting. So I would like to thank the two previous speakers in particular. Sorry if I've been too long.
Not at all. Thank you very much, Christophe. And really appreciate your comments. And we would absolutely agree that, as you pointed out, there's still room for improvement in countries even where SDPs do exist. And we should definitely exchange our notes on the number of SDPs. I think Luxembourg isn't currently in our index, so we haven't analysed the situation closely in Luxembourg, but mostly they coincide, the numbers. And of course, it's always great to hear that statelessness, identification and determination of statelessness is a priority area of the work of the Council of Europe. And we are delighted to be working closely with you and colleagues at UNHCR to participate in the conference next week, and very much looking forward to discussions there. So I'm going to ask you to leave your camera on. We have a few minutes, and I'll ask the other speakers to turn their cameras on now as well, if they're still with us, hopefully. And we've had a couple of questions, and I'll summarize the questions that we've had and then just give you each a minute to share any closing reflections or responses to the questions. So we did have a question about any tips for approaching governments that don't have SDPs in order to encourage them to introduce SDPs. So that might be one maybe Marlotte or Lynn or Patricia could share, or indeed Christophe could share any tips that you can think of. And there was a question about the vague requirement of good character clauses in naturalization procedures, which is a very good question, quite a technical one, but Patricia might have a thought on that. Or we can also, I think other colleagues who are online with us in the chat shared an example from the UK in response to that one. So anything on naturalization and good character, or tips for approaching governments, or anything else that you would like to share in response to what you've heard today would be really welcome. So I'll give you a minute each, if I may, and I'll start with Lynn. Would you like to go first?
Yeah, sure. Tips. Yeah, I mean, I think what we're doing today is great, and like the so I do have a lot of technical problems today, so excuse me. And then you just got by surprise by your question. Yeah, I think also considering stateless people in the whole procedure, that this is about them to actually, like I'm doing today, you included me and you're asking me questions. And I think that's how it should be in every single country, that if you're trying to solve an issue, maybe you should go to those people that are suffering from the issue the most. What is it that might be, if, for example, if I'm in a country where I don't need to fight to prove to them in the first place that I'm stateless, if they have a procedure to determine stateless people, then I don't need to carry all the burden to prove to them that first I'm stateless, and also I can't go anywhere. So if you're trying to deport me there, so it's like having the knowledge and the will to solve this, and like using the index that you people are doing. I think the more countries that are included there, the easier it is for people like me to get out of this suffering. That's pretty it, I think.
Thank you so much, Lynn, and wise words and tips as always. So thank you very much. Very briefly then, I'll hand over to Marlotte, and then Christophe, and then Patricia for the final word. So Marlotte, over to you.
Thank you. Yes, I would say I totally agree with what Lynn mentioned. I think it's very important for civil society to work together, to include different organizations, to include stateless persons, and be very, like Lynn said, their knowledge and what they experience is most important to highlight. For the Dutch context, it was helpful, like I said, that there was a critical mapping by UNHCR. So I don't know if that is helpful, maybe in other contexts, also to initiate. And also it left room for critical questions by MPs to also reach out to the government about the current context and the need for change. So also to include the governmental and parliamentary process in that regard.
Fantastic. Thank you, Marlotte. Christophe, very briefly, a minute from you. Any tips?
Yes.
Or any final words?
Yeah, thank you, Nina. I don't have any practical tip or advice to suggest, but working on a daily basis with governments, you see, most of the time governments are concerned about possible additional burden that may result for them in taking a new obligations, new duties. So I would suspect that a number of the countries that do not have procedures in place consider that it's another problem for them They may have fears even. So I think I would develop an argumentation to show to them that it's not at all a problem, but more an asset for them. The people who suffer from statelessness are an asset for their societies. So they should try and settle the problem of these people in the interest of everyone, not only these people, but also their own country, their own society. I would say settling the problem would be a kind of a win-win situation. So I would address the problem, the governments that way, and I would explain to them that some countries have done the effort already, and they have not been faced with tremendous problems in practical terms. So I think if some have done it, others should be able to do it as well.
Fantastic. Thank you, Christophe, and wholeheartedly agree with that tip. Patricia, a final word from you before we close?
Sure. And I think everyone has already said great tips for the states. On the question of good character and criminal convictions, I mean, I won't dwell into it, but sometimes they are different, and sometimes the criminal convictions may be included within the good character requirement. Other times the good character requirement might be a bit wider and also include things like overstaying in the country, for example, which is not a criminal conviction. But we're happy to answer more specific questions and give examples via email, for example. And I think as a final word, my key message is really that we need more and better statelessness determination procedures. Countries that have not acceded to the 1954 Convention need to accede, and all countries need to introduce SDPs, and these need to be in line with international norms and good practice. And for this, the Statelessness Index is a great tool to benchmark against international norms and good practice and really understand where are the key areas where each state still needs to work on. And we're very happy to work with government actors and civil society to address this.
Fantastic. Thank you so much, Patricia, and a huge thank you to all of our speakers for joining us today. It's really been fantastic to have your expertise and contributions, so we're really grateful for the time you've taken. Thank you to all of you who've joined us from all corners of the globe. We've seen in the chat today, and still nearly 80 of you here with us to the end, so that's really fantastic. Thank you for staying with us, and do share the recording with colleagues who weren't able to join us today. We encourage you to read the briefing and to share it around your network and to think about how we can work together to address these key issues that were highlighted today. In the meantime, we will share presentations and the recording, as I said, and we really look forward to discussing these issues further in Strasbourg next week, both virtually and in person. And with that, it's just left for me to wish you a great rest of the day or evening, depending on where you are. Stay safe and goodbye. Thank you.